all the viewers. Myself, Dr. Rajesh Kumar Singh, Associate Professor from Parul Institute of Law, Parul University. First of all, this is the very important topic that all the students should learn, and this is on the Civil Procedure Code and its development. So, first of all, I will introduce our speaker, who is the advocate from the Supreme Court, Prachi Pratap ma'am. So, just of all, I will give a brief introduction. Prachi Pratap Madam studies law from the University of Lucknow, and she is the partner with Pratap and Pratap Company, a law firm based out of Delhi. Prachi ma'am has diverse litigation experience in the High Court as well as in the Supreme Court. Prachi madam is the counsel and she advises, represents her clients on the legal affairs in relation to the civil and criminal matters, company matters, and insolvency and bankruptcy code with the service matters, matrimonial property, as well as the land and acquisition matters. Moreover, she also deals with the arbitration and the debt recovery matters. Prior to completing the law schools and commencing her legal career, Prachi Madam has worked as a social entrepreneur and she has delivered lectures and presentation on the same. She has also worked closely with many non-profit organizations in discussing the policy implementation and ground level. Prachi Madam has a long-standing commitment for the right of the children and women, and she is also a vocal about the environment protection and pollution. She has written her views on the same for the Quint. Prachi Madam is also regularly attend the conferences in India and abroad for continued professional development, including the GAR live events and American Society for International Law. She had delivered various lectures with the different universities. So now I will like to say about Dr. Akhil Sayyed sir. He is the director and dean at Parul Institute of Law, Parul Institute ma'am. And I request Dr. Akhil Sayyed sir to warm welcome our speaker, advocate from the Supreme Court, Prachi Pratap ma'am. Dr. Akhil sir.
Thank you, Dr. Rajesh. Thank you very much. Thank you for giving me the mic as well as I thank you for inviting learned advocate Prachi ma'am on this virtual platform of Parul University and giving all of us an opportunity to have an interaction with us. Ma'am, Professor Dr. Akhil Sayyed, Dean Faculty of Law, on my personal behalf, on behalf of Parul University and Parul Institute of Law, cordially welcome you, ma'am. Sadar Pranam. It's a great pleasure that you are here with Parul University, and I learned that you have been engaged in so many organizations and so many assignments. But despite of your busyness, you have spared your valuable time for us and our students. So we are very much thankful to you, ma'am. And with this webinar, not only the webinar might be ended within an hour or so, but our association will remain continue. I invite you to have your personal visit at the Faculty of Law, Parul University. Ma'am, ours is the private university established in 2015. And at Faculty of Law, we do offer 5 years integrated program, 3 years LLB program, MPhil program, LLM with 8 different specialization, and also PhD program. So your expertise and that too particularly civil procedure code. Uh, Dr. Rajesh mentioned that it is a very important subject for the student. I would extend that not only for the student, for the practitioners also.
Right.
This is a typical subject where they find the trouble most. So when person like you practicing at the Supreme Court is simplifying that subject, so I am sure not only my students but my colleagues, teachers, and many practitioners who are watching you on this Facebook Live will be getting a new insight for the subject. Thank you, ma'am. Once again, thank you, and please do come at our university. Thank you very much.
Thank you so much, sir. And I'm so delighted and grateful to Rajesh, sir, for inviting me. He is so popular here in Delhi and especially in Supreme Court. Almost everybody knows. We wonder why he's not here with us. But and thank you, Akhil sir, so much for having me here. So I think we can just start with the presentation since everybody is on a timeline at the moment. So, okay, let's begin. So we're going to discuss Code of Civil Procedure and with the developments, which would also include the latest judgments. So when a procedural law is considered, it is retrospective in nature. But however, here we are going to discuss it as retroactive because it was earlier considered that procedural laws are retrospective. But now we know that since Civil Procedure Code and such procedural laws are there, came into effect from the past date. So the question of retrospective operation, the civil law may have retrospective action as retroactive operation. So, in the case of Syed Muhammad Bakr versus Abdul Habib Hassan, Supreme Court expressed that procedural law is usually in aid of justice, not in contradiction or defeat to terrible object that is wanted to be achieved. Procedural law is usually subservient to substantive law. Nothing is often given by a procedural law that's not sought to be given by substantive law, and nothing will be removed by the procedural law what's given by the substantive law. We should also know that in the retrospective operation, it is a well settled principle of interpretation of statutes that procedural laws are perpetually retrospective in operation unless there are good reasons to the contrary, which was held in Nani Gopal Mitra versus State of Bihar. The provisions can apply to proceedings already commenced at the time of their enactment. The explanation is that nobody will have an unconditional right in kinds of procedure, which was maintained in Anand Gopal versus State of Bombay in 1958. So, further, as the popular case of Mohanlal Jain and versus Vaiman Singh Ji was there, the Code of Civil Procedure isn't retrospective in operation. The century old, so as we all know that CPC is over a century old, the Code of Civil Procedure was first codified in 1859. At that point, there was no uniform law applicable to the whole of India. The subsequent Code of 1908 aimed at consolidating and amending the laws relating to procedure of the courts of civil judicature in India. So we should also know that in 1859 that the law came, we had presidency and provincial courts at that point, which were governed by different regulations. So further in 1908, when the amendment, when the Code of Civil Procedure came, it tried to unify the subjects of India and the laws under one code. Since then, the Civil Procedure Code has been amended many times. The 14th report of the Law Commission in 1976 made some major amendments. After that, on the basis of the Malimat Committee recommendations, Code underwent two major amendments. Act number 46 of 1999 and Act 22 of 2002, which we will discuss in detail further. And one of the major developments that we saw recently in CPC was the introduction of Commercial Codes Act 2015. CPC has been amended multiple times, a notable one being in 2002. The concept of natural justice is enshrined in the preamble and includes a fair trial, impartially, good faith, reasonable time, fair notice, etc. These principles find echo in provisions of CPC and have been reaffirmed in a veracity of judgments, mainly the rule of audi alteram partem, the right to be heard, nemo debet esse propria causa, no one shall be a judge of his own case. Other principles include the right to legal aid, speedy trials, lok adalats, and so on, including res judicata. The CPC has been a constant state of evolution to keep in consonance with the rules of fair trial. So that is one of the principles that every court, every file that we are doing, every judgment has to ensure that there is regard given to the fair trial. Various efforts have been made by the law to improve the procedural code of civil proceedings by amending the acts at certain intervals, as and when they feel that the society is changing or new other peripheral laws are coming, we amend CPC accordingly. That's how the Commercial Code Act also came, because we know that post LPG, there was more business in the country, more open. So we needed more laws to govern those things. So the Act of 2002 was met with little resistance and proved to be more effective than the one in 1999. The 1999 Act had imposed the 30-day limit on the defendant to file a reply to the summons, which was objected to by the lawyers. The 2002 Act provides 3 months for reason to be recorded in writing by the court. The 1999 Act substituted Section 102 of CPC to provide that no second appeal shall lie from any decree when the amount or value of the subject matter or the original suit did not exceed 25,000. Critics pointed out that it would foreclose second appeals even in cases where a substantive question of law was involved. It was argued that the revenue being nominal, the jurisdictional value of all suits arising out of rural areas and agricultural land prescribed as certain multiple thereof would never reach rupees 25,000. So as we see that focused on the lower class of the society, the agriculture, which constitute a major chunk of the population. So the new amendment tried to cover everyone involved in production in India. So this 2002 amendment would have created this 99 amendment would have created an unfair distinction between two classes of litigants, with the right to second appeal available only for the moneyed class. So in order to not let the agricultural class suffer and for them to have an access to justice, the 2002 Act was corrected, was set out to correct the distinction made, and they corrected it by specifying that no second appeal shall lie from any decree when the subject matter of the original suit is for recovery of an amount not exceeding rupees 25,000. So now let's have a look at a brief preview of the look at the amendments of 1976. So the power to transfer proceedings from one high court to a different court is conferred upon Supreme Court. Freedom from attachment of a portion of regular payment to any or all salaried employees was granted. Provision of giving notice under Section 80 before institution of a suit against the government or public officer was made less rigorous. Restrictions are obligatory on the right of appeal and revision. Provisions were created to make sure that written statements and documents were filed without delay. New Order 32A was inserted to provide a special procedure in a judicial proceeding regarding the affairs of a family. Now, the amendments through 99 to 2002 we'll discuss in brief. So I'm just giving you an overview of the past amendments, and then we will touch some judgments that will help us see how laws evolve and how the judiciary helps in evolution of CPC. In many matters like provisions of issuing summons, filing of written statements, amendment of pleadings, production of documents, examination of witness, pronouncement of judgment, preparation of decree, time limit was prescribed. The adjournments was restricted, as we all know that often one party takes adjournment, the other party takes adjournment, and so on and so forth. The time period of a case gets extended up to 20 years, which is considered normal in courts. So the amendment restricted the number of adjournments. A provision for recording of evidence by court commissioner was made. Endless arguments were sought after to be shortened by empowering the court to repair a time limit for oral arguments, by permitting written arguments to be placed on records by the parties. So when written arguments are placed on records and the time limit is given for oral arguments, of course, we see that we are saving the time of the court in a country where there's so much pendency of cases. Such a development in the Act helped us to get more and more cases to be sorted out, to be decided. A provision was created for filing of an appeal within the court which passed the decree. Instituting of appeal against the judgment is allowed wherever the decree isn't drawn up. Next, we will touch the Commercial Courts Act of 2015. So here I've listed the basic points, but I will just touch them a little more in detail. So we should start with the Section 16 of the Amendments to the Code of Civil Procedure, 1908. The Section 16 of the Act states that this Act will have overriding effect on the provisions of CPC. So, sorry, the Section 16 that we are discussing here is of Commercial Courts Act that said that it will have an overriding effect on the provisions of CPC and its amendments. It clearly mentions that in case of conflict between any rules of the code, the rules of jurisdictional high court, or any state amendments made to the code, the provisions of the Act as it amends the code will prevail. So there was a landmark case of Axis Bank versus Mira Gannon. The Bombay High Court held that the amendments introduced by CPC by the Commercial Codes Act are only applicable to the commercial disputes of a specified value and not commercial disputes of not of a specified value, such as the present suit, which was the Axis Bank. Now, the changes made to the CPC. The first change was cost. The costs are discussed under Section 35 of CPC. The set section provided discretionary power to the court while determining the cost. The Act has substituted the set section to provide a general rule of payment for cost by unsuccessful party. Second is procedure for summary judgment. As we all know, that summary judgment was introduced through a new order, Order 13A in the CPC. Summary judgment is given by the court without recording oral evidence in the following scenarios, which includes applicant may apply for summary judgment at any time after summons have been served to the defendant. So next is pleadings in a commercial dispute. Order 6 of CPC deals with pleadings. The form of pleadings in commercial dispute will be as per High Court rules or practice directions provided for such disputes. A new Rule 15A has been inserted, which pertains the verification of pleadings in a commercial dispute. In absence of verification of pleadings, the pleadings cannot be relied as evidence. The third is delay in filing written statement. The maximum period within which the written statement could be filed is 90 days under CPC. The Act has increased the time period to 120 days. The Commercial Codes Act has increased the time limit to 120 days. Accordingly, the Act has amended Order 5 of CPC dealing with issue.
Ma'am, hello, ma'am. Actually,
Yes.
this screen is not displayed. Yes, now it is okay.
Oh, okay, sorry.
Uh,
Now can we read it? Can we see it?
yeah. It is. It is. I think the case law which we were explaining at that point of time, it was not displayed.
Right, so all the case laws are not displayed here, but I'll email them to you separately.
Yeah. Okay, ma'am.
We'll do that. So we'll just cover the Commercial Codes Act quickly. The procedure for disclosure, discovery, and inspection of documents before the commercial courts. So the procedure, again, Order 9 of CPC lays down the procedure for discovery and inspection of the facts of the suit through interrogatories. The Act substituted this order to include disclosure along with discovery and inspection of documents. Under the new provisions, parties were required to file a list of all documents and photocopies of all these documents at the stage of filing of plaint or written statement. Next is electronic records. The evidentiary value of electronic records has already been recognized under the provisions of Indian Evidence Act and IT Act. The Act incorporated the relevant provisions providing procedural rules in respect of the same under the new Order 9 of the CPC. So we should also see how Commercial Codes Act, which has amended CPC, also kept into consideration the laws given under Indian Evidence Act and IT Act. So this is again part of the development that we are facing. Now the next is written arguments. Order 23 of the CPC deals with hearing of suit and examination of witnesses and consists of provisions pertaining to written arguments. As per the new provisions in this order inserted by the Act, parties have been mandated to submit concise written arguments under distinct headings within 4 weeks of commencement of the arguments, the oral arguments. And any other revised written arguments can be filed within a week. The next is amendment in procedure related to affidavits. The Act inserted new rules in order of a CPC, the order, I'm not remembering the order number, but in addition to the existing procedures related to affidavits, courts have been empowered to control the evidence by being permitted to decide the issues which require evidence and the manner in which the evidence has to be recorded. They have been empowered to redact any affidavit which in their view does not constitute admissible evidence. The time period for pronouncing judgment again has been increased from 60 days to 90 days from the date of conclusion of arguments for pronouncing of judgments. The case management of hearing. So the CPC Order 15A a new order was inserted. This allows the court to make a timeline and fix dates for the proceedings of the matter. So let's look at some cases now, which gets more interesting than going into the Bare Acts and the briefs of Bare Acts. So now we are going to discuss Order 9, Rule 13 of CPC, where Supreme Court held that defendant who refused summons not entitled to seek setting aside of ex parte decree. In the case of Vishwabandhu versus Sri Krishna and another, the Supreme Court had set aside a judgment of the High Court, which had allowed the setting aside of an ex parte decree under the Order 9, Rule 13 of the CPC. In this case, the defendant had refused to accept the summons issued in the suit. After the suit was decreed ex parte, execution proceedings were initiated. The defendant duly acknowledged the receipt of auction notice with respect to the suit property. It was only after the auction was undertaken that he preferred the application under Order 9, Rule 13 of the court. Through the trial court rejected the application, the High Court allowed the same in appeal. The High Court observed that the defendant was not vigilant as he ought to have been. It added that the conduct does not on the whole warrant to castigate him as irresponsible litigant. Now let's see the Supreme Court's view on the same. So High Court also said that the inconvenience caused to the plaintiff on the account of absence of appellant may be compensated by awarding appropriate cost. However, the aggrieved party went to the Supreme Court, and the Supreme Court, in a bench comprising of Honorable Justices U. Lalit and Justice Ravindra Bhatt, noted that the Sub-Rule 5 of Order 5, Rule 9 of the court states inter alia that if the defendant or his agent had refused to take delivery of the postal article containing the summons, the court issuing the summons shall declare that the summon had been duly served on the defendant. The bench also referred to Section 27 of the General Clauses Act 1897, which gives rise to presumption that the service of notice has been effective when it's sent to the correct address by registered post. It was also noted by Supreme Court in Alavi Haji versus Palapati Muhammad and another case in 2007, where a notice was sent by registered post and it was returned with a postal endorsement said refused or not available in the house. So it was maintained that if someone says refused, not available in the house locked, shop closed, addressee not in station or out of station, it will be presumed that the due service has been done. And here we also refer to the General Clauses Act, and it is pertinent to note that General Clauses Act has always been important to read along with CPC. Even in some of the recent cases where the Supreme Court has dismissed the case, it has referred to General Clauses Act to give their judgment for dismissing. So in this particular case, where we said that the defendant who refused, it was noted that in light of the features indicated above and the fact that the auction was allowed to be undertaken, the respondent number 1 was disentitled from claiming any relief as was prayed for. Further, after completion of proceedings in auction, sale certificate was also issued in favor of the appellant. So the court set aside the High Court judgment which allowed the application under Order 9, Rule 13 of the CPC. Now let's get to the next case, which is a plaint cannot be rejected under Order 7, Rule 11D of the CPC if the issue of limitation is a mixed question of law and fact. Now again, this is one of the really good cases and by our Honorable Senior Mr. Nafre. So the case title is, of course, Salim D. Abgodwala and others versus Shamalji, Uddhavji Thakur and others. So in this case, I'll just give a brief summary. The appellant had filed a suit for administration of land before Bombay High Court, which appointed an administrator for the land. The appellants were legal successor of the land stated, and some of the sales of land were done by fraudulent mutation of the land through Agricultural Land Tribunal without appellant's knowledge. The appellant filed a suit in 1987 upon gaining knowledge of the order passed by Agricultural Land Tribunal in 1963. So the order was passed in 63, but the appellants gained knowledge of it in 87. So, of course, by prima facie, it looks like that the case is barred by limitation. However, the appellants reached the court, the district court. So let's look into the issue. The respondents sought rejection of plaint on two grounds. The suit filed in the year 1987 challenged the action of the competent authorities that the Act carried out way back in 1963 and 64 was barred by limitation. And they also said that the section 85 of the act bars the jurisdiction of the civil court. So they also said that it's not under the jurisdiction. The plaint was rejected by the city civil court. So this is a case in Maharashtra, and it was rejected on both grounds. And the same was upheld by Bombay High Court. However, when they approached the Supreme Court, the Honorable Supreme Court cited the following judgment in maintaining the suit and not barring it on grounds of limitation. The Supreme Court had earlier held in P.V. Guru Raj Reddy versus P. Neeradhra Reddy and others that rejection of plaint under Order 7, Rule 11 is a drastic power conferred on the court to terminate a civil action at the threshold. So we should know that in not only in this case but in previous case it has been held that a case should not be rejected at threshold. Everybody has a right to justice and they should be find a way to approach the court and let the court decide. So again we are touching the concept of fair trial that we discussed in the beginning of this presentation. So when a plaintiff claims that he gained knowledge of the essential facts giving rise to the cause of action only at a particular point of time, the same has to be accepted at the stage of considering the application under Order 7, Rule 11. Again, as pointed out by a three-member bench of the Honorable Supreme Court in Chotanben versus Kirtibai Jalukrishnabhai Thakkar, the plea regarding the date on which the plaintiffs gain knowledge of the essential facts is crucial for deciding the question whether suit is barred by limitation or not. It becomes a tribal issue, hence the suit cannot be thrown out at the threshold. So this clearly states that it should be allowed in the court and it should not be barred by limitation. The court also noted that once the appellant gained knowledge of the fraud and ALT order, they approached the court and the suit was not barred by limitation. When a plaintiff claims that he gained knowledge of the essential facts giving rise to the cause of action only at a particular point of time, the same has to be accepted at the stage of considering the application under Order 7, Rule 11. And now, this being a reportable judgment, we are also extremely excited to use it in our future proceedings. So the next is Section 13. So this is a personal favorite of mine because often we are asked about whether a foreign judgment is conclusive in India or not. So we need to see I'll cover a couple of cases of Marriage Act because foreign judgments in divorce cases often come up, not only in the Supreme Court, but of course often in high courts and even at district courts, because foreign judgments, as we know, are a foreign decree can immediately be admitted in a district court. So let's see, are foreign judge decrees enforceable in India? The Section 13 of CPC says that a foreign judgment is not conclusive as to any matter thereby directly adjudicated upon between the parties, if it has not been pronounced by a court of competent jurisdiction. Also, many provisions for divorces available abroad are not maintainable under different marriage acts in India. So here we will quickly touch two case laws. One of them is Balasubramaniam Guhan versus T. Hemapriya. So in this case, it was, let me just get into it. So yeah, so the divorce decree was passed by the court in Scotland, and it said that it was maintained, the suit filed here, it was said that it was ultra-vires, unsustainable, illegal, unenforceable, and without jurisdiction. The fight prayed for consequential injunction restraining the petitioner to enforce the decree or to take a second wife. The court held that the foreign judgment falls under the clauses of Section 13 CPC, and it will cease to be conclusive as to any matter thereby adjudicated upon. In the absence of the conditions mentioned under Rule 11, Order 7 CPC or any other valid grounds, the revision application filed by petitioner husband was dismissed. And in the second case of Hima Chuk versus Pritam Ashok Sadapule, the parties were married in India but they were living together in UK. The husband filed for a divorce in UK and he received a decree nisi. So a decree nisi is a decree which is issued and which is there for, it's like a temporary decree for some time and then it will be considered permanent. So during the decree nisi, the wife had filed a petition in the Delhi High Court in India. And it said that since both the parties were Indian and were married in India and were governed by Hindu Marriage Act, so that decree which was issued in the court in UK will not be valid. So here it should be noted that the High Court maintained that this was again in violation of Section 13 because the marriage was dissolved by the Ilford County Court in UK. And the grounds of marriage to be dissolved were irretrievable breakdown of marriage, which is not a ground for dissolution of marriage under Hindu Marriage Act. Hence, the decree cannot be recognized as facts of the case fall within the purview of exceptions mentioned under Section 13 of CPC. So next we will discuss about the reciprocating territory. After the Marriage Acts, which a lot of divorce cases which are read along with the Marriage Act and CPC, let's look into more of the commercial transactions. And this one is one of my personal favorite cases. And actually, I think everybody's personal favorite case in terms of reciprocating territory. So Section 44A of the CPC, read with Order 21 of the CPC, talks about the reciprocating territory, which means any country or territory outside of India, which the Indian central government may, by notification in the official gazette, declare to be a reciprocating territory, and superior courts in relation to such a territory for this section. So some of the territories that we know are reciprocating are UAE, UK, and now we will discuss this case, which is with United Kingdom. But let me just give a brief of the Section 44. Okay, actually, let's just discuss it in terms of this case. So again, we will look at how Section 13 was used in this case. So in Kevin George Vaz versus Cotton Textiles Exposed 2006, the case related to the term of reciprocating territory was extensively defined to mean any country or territory outside India. For the record, the UK has been reciprocating territory with India under the provisions contained in Section 44A of the CPC, which was, of course, the amended one. Then in this, this particular case deals with Hong Kong, which was a colony and British dependent territory of the UK. But it was restored to the PRC, People Republic of China, in the year 1997. So this particular case proceeded when Hong Kong was under British rule, but part of PRC under its sovereignty. So there was a jurisdictional issue at play over here. And so it was needed to know whether this will be considered as part of the reciprocating territory. So the key issue facing above the contingency was whether an act of central government recording a territory as reciprocating territory would lose its legal stand and authority by virtue of such country ceasing to be part of a country that is in fact a reciprocating territory. So here we see that, okay, Hong Kong was part of British. We have a reciprocating agreement with British, but it is no longer part of that. It is now part of China and we don't have an agreement with them. In deciding of such contingency, the court took a considered view of the legislature's intent and stated that the legislature was well aware of all such contingencies. The court interpreted the term territory outside India to include territory that may be part of a country in addition to territory that may have ceased to be part of a country. To support such a view, the court examined the legislature's intent and rationale to hold that when such contingencies occur, Care is taken to see that the holder of a foreign decree does not suffer. Accordingly, in view of the foregoing, the court did not accept the contention of the council that upon Hong Kong becoming part of PRC, it ceased to be a reciprocating territory and would have no legal effect or implication post 1st July 1997. So here we see that again how we have used Section 44A in dealing with a matter which is tricky in terms of territorial jurisdiction, but again how CPC has come to rescue, and a new judgment has set forth a precedent by being reportable and being used in other cases where we don't have a reciprocating agreement, but we benefit by not allowing such foreign judgments to overrule us. So another will be Order 8, Rule 6 of CPC, which mandates embargo on filing the counterclaim after filing the written statement. Here, in case of Ashok Kumar Kalra, who was a Wing Commander Surendra Agnihotri and others, the case was whether the Order 8, Rule 6 of CPC mandates embargo. So, a dispute rose between petitioner and respondent concerning performance of agreement to sell, and the respondent filed the suit for specific performance against the petitioner. Petitioner then filed a written statement counterclaimed in the same suit. The trial court rejected the objections concerning filing of the counterclaim after filing of the written statement and framing of issues. The order was then challenged before High Court. The High Court allowed the same and quashed the counterclaim. Aggrieved by the aforesaid order, the High Court, the petitioner filed and approached the Division of Supreme Court, which referred the matter to the three judges bench. The three-judge bench agreed with the decision of the trial court and asked to place an instant SLP for obtaining orders from the Honorable Chief Justice of India for considering the case on merits. The intention behind Order 8, Rule 6A of CPC is to provide an enabling provision for filing of counterclaim, so as to provide multiplicity of proceedings, thereby saving time of the courts and avoiding inconvenience to the parties. No specific bar has been imposed on court's jurisdiction to entertain a counterclaim except for limitation under the said provision, which says cause of action in the counterclaim should arise before or after filing of the suit, but before the defendant delivers his defense. So the three-judge bench, comprising of Honorable Chief Justice, Justice N.V. Ramanna, it was held by the court that once issues have been framed, court cannot entertain counterclaim filed after submission of written statement. So this actually helps save time of the court, and it helps us maintain that both the parties have equal access to what is being said and no counterclaims are being made at the end. So that is a brief thing, trying not to take too much time, and
Yes, yes,
if
ma'am.
you ask questions.
Yes, ma'am. A very fantastic session by you, ma'am. Ma'am, I'm audible to you.
Yes, sir, you're audible. Just I'm trying to close this down.
I think you just stop sharing.
Yeah,
That's
you want me?
yeah. Madam, our student have certain questions, ma'am. The first question from one of the student that if suppose there is someone has filed in the junior division,
Yes, sir.
case has been filed in junior division, and it has been rejected in the junior division, where he will go?
So of course, it will go to the next. It depends upon the case. It will go to the next level of appeal, but it definitely depends, as you know, upon the case of what type of case we are dealing with, and if it is maintainable in the next level.
Okay, ma'am, in Delhi, if I will talk about Delhi, the High Court has a original jurisdiction to take a matter more than 2 crores, and in different states we have different pecuniary jurisdiction as per the different states. Correct.
Right, sir.
So, ma'am, if suppose Delhi High Court has been given a power, and recently I have learned in one of the important judgment where the Delhi High Court has a power to take a matter more than 2 crores. So if suppose a matter is to be entertained by directly by the Delhi High Court, so what these lower courts will do in Delhi?
So I didn't get you. Okay, so if the court is taking the matter of 2 crore, so
Uh,
what will the lower
yeah,
courts do?
because if I will talk about in Gujarat,
Right.
particularly at Vadodara, because district court has unlimited power to entertain any matter, and then if it is challenged, then it will go to the High Court. Correct?
Yes, sir.
Okay, but the question is, say for example, in Baroda, if suppose my senior division, okay, let us
Right.
suppose I am talking about the senior division courts. Senior division has a power, say for example, they can take more than 20 lakhs rupees, and even though the district court has an unlimited power, so why a certain union territory has given certain different jurisdiction for taking different matters?
So I don't have a case law right now to refer to it, but what my experience and your experience, of course, shows it is because, of course, our high courts are overburdened based upon the population and the number of cases that come in the jurisdiction. So they have put a threshold limit so that our overburdened courts are not overburdened by litigation. And as you know, now we are stepping into a time where the courts also prefer that a lot of lesser value cases are settled out of court and through ADR and mediation, and arbitration is coming up big time. And I think one of the reasons we got the Commercial Court Act also was so that the division keeps happening.
Yes, ma'am. Yes, ma'am.
Right.
Madam, one more question that in order 41, because you know that you can challenge against the decree, correct?
Hmm.
Order
Hmm.
41. Suppose you want to challenge a decree, you can go in order 41.
Right, sir.
So, ma'am, say for example, if suppose I go to the first appeal and it was rejected, then after that, where I will go?
So, as you know, the appeal is a remedial concept, and if the appeal is rejected, then again we will go to the superior court. I mean, that is the basic
Yes,
principle
exactly.
of going to the superior court, but it
Exactly.
depends upon where we have filed for it and under what all other, as you say, it is a commercial matter, it's some other matter. I mean, it's matrimonial, whichever way it is, and then we will go to the next superior court, which is adjudicating.
Madam, one more question from one of the student that suppose the limitation period has been elapsed, correct? So we generally file condonation of the delay.
Right, sir.
So is the courts are permitting easily this condonation of delay?
So, I would honestly, I would say it depends from case to case. Of course, it depends from case to case. But yes, condonation of delay is allowed, and in light of the new judgments that we have seen, the one that I recently discussed, and another one which is the Shakti Bhog case judgment, which I have not discussed, but I will share. I'll forward it to you. We have seen that courts are allowing. The limitation period to be skipped in order to consider the merits of the case and then decide if a case is actually barred by limitation or not.
Okay. Yes, ma'am. Now, what is the time limit for the counter claims? Suppose someone has going to reply and he has to reply for the counter claim. What is the time limit?
Uh, just a minute, sir.
It
So,
doesn't matter.
no, the counterclaim for reply, of course, if you're talking about under the Limitation Act, the arbitral tribunal would say that within 3 years from the date of cause of action, a counterclaim has to be done. Right?
Okay. Okay, ma'am. Madam, pertaining to the injunction, temporary injunction, Order 39. Now, if suppose Order 39 has been passed by the Honorable Courts,
Right.
now if suppose person want to apply for the permanent injunction in the specific relief act, so what is the provision in our law for applying for the permanent injunction?
Sir, there was a case on it where the Supreme Court had said that can a defendant seek injunction in a suit filed? Uh, Order 39, Rule 1 of CPC we were discussing. And I would like to say that permanent injunction. is allowed, but of course there's again, they have maintained in one of the cases that I was reading recently, where they said that this idea of going from injunction, one part injunction, you are delaying it. It's recently it was said that it's basically a delay tactic, and it should not be permanent. And I would actually find that case and share it with you, because that's a very
Sure.
good point you have pointed. And I'm
Yeah.
sorry I forgot to discuss it. It's a brilliant thing you have said, because
Yes.
I'm sure you must have read that judgment where it
Yeah.
discusses about how injunction has been used as a delay tactic.
Yeah, ma'am. Ma'am, this was very fantastic session by you, and we have learned a lot
Sir,
from
I'm
you.
learning so much from you, so I should be grateful to
No,
you.
no, no,
I mean,
but
person like you saying is a
yeah,
big deal.
but it is, because you have made a very fantastic PPT and you have explained with a very good case laws, so that is very appreciated, ma'am.
Thank you,
And
sir.
even though my students are, we have put it our video on in the classroom, they are all seeing this webinar. So we are very much thankful, and on the behalf of Parul Institute of Law, Parul University, ma'am. So already Akhil sir had already told you to him, and he has also invited you at our university. So, ma'am, whenever this situation will come, we will definitely like to see you in our institute, ma'am. So,
Thank you
on
so
this
much, sir.
note, madam, we are very much thankful to you, and I am also thankful to Brijesh Kubhani sir and Mr. Jatin Kubhani sir, who has imparted this webinar on the Facebook. So, it is a very fantastic session, ma'am. So, now we are closing this session.
Thank you
Thanks a
so
lot,
much,
ma'am.
sir. Thank you
Thanks a
so
lot,
much,
ma'am.
sir.
Thanks a lot for your kindness. Which is that we are closing.